Today, we are going to talk about the concept of res subjudice. Res subjudice is given under Section 10 of the Code of Civil Procedure. Before we start, there are few differences between res judicata and res subjudice. The first difference is that the concept of res judicata applies where the former court has already heard and finally decided the case, whereas the concept of res subjudice applies where there are two currently pending suits and the subsequent suit is stayed. The second difference is that the concept of res judicata is the bar when there is a subsequent suit and it is a bar on the subsequent suit, whereas the concept of res subjudice provides for stay or subsequent proceedings of the suit. In res judicata, the next or the subsequent suit does not have a standing at all, and in res subjudice, the subsequent suit is stayed rather than it is dismissed. There are four main essentials of res subjudice. 1. Pendency of suit. 2. Same parties. 3. Same title. And 4th, matters in issue. Let us walk through the first essential, that is pendency of suit. Whenever there are two suits filed and we need to apply the concept of res subjudice, we must look at the fact that if any suit has been decided by the court or not. If the court has decided the suit, then the principle of res judicata will be applicable. But in a situation where both the suits are pending before the court, the principle of res judicata is not applicable. Rather, the principle of res subjudice comes into picture. The subsequent suit will be stayed to proceed. The second essential is that the two suits pending before the court must not have the same parties in respect to the subject matter. Parties include legal representatives, legal heirs, and also the people who have received the subject matter by way of legal process. An example of this could be that if A has filed a suit against B claiming damages to property Z, and meanwhile the property is sold to C by A, C has also, by virtue of legal process of sale, become a party, and if the subsequent suit is filed by C against B, then it will be construed that both suits have the same parties. The third essential is that the parties in the subsequently instituted suit must not have the same title as they had in the previously instituted suit. Title can be defined as the legal status or the legal capacity of the party that it has with respect to the subject matter in suit. So, if A has filed a suit against B as owner, he cannot subsequently proceed with another suit in the legal capacity of an owner. However, he can file it in the capacity of a mortgagor, provided that there has been a transaction of mortgage. The final essential ingredient is that the matters in issue of the two suits in question must not be the same. Matter in issue is the fact from which the legal title of a party is derived. There are two types of matters in issue. First, matters directly and substantially in issue, and second, matters incidentally and collaterally in issue. Any matter which is essential for a just and final decision of the suit on merits is a matter directly and substantially in issue, and res subjudice will be applied upon these kinds of matter in issue only. Any matter which is not essential to be decided for the final decision of the suit is a matter collaterally and incidentally in issue, like the matter of bail is not a matter which is used as a merit for final decision of the suit. To know more about it, you can refer to our video on res judicata. Coming to the explanation of Section 10 provides that if a suit is pending in a foreign court, it will not affect the jurisdiction of the Indian courts to try such suit on the same cause of action. So, if A files a suit in a foreign country, for example Britain, and thereafter files a suit in India, such Indian court will be competent to try the suit even if the cause of action is same. Lastly, a situation may occur where a person, after filing a suit in a court, files another suit in the other court, and the court in the subsequent suit has passed a decree. Here, the question arises that what will be the nature of the decree passed in the subsequent suit by the court. In the subsequent suit, the decree passed is an irregular decree and not a void decree, as the irregularities can be removed by completing the proceedings in the previously instituted suit. However, we need to check that the court which passed the decree in the subsequent suit is competent or not in order to apply the principle of res judicata and other essentials as such are fulfilled or not. While determining the applicability of res judicata in this present situation, the court in which the subsequent suit is filed will be considered as former court as it has decided the suit after hearing the case. Thank you for watching this video. If you liked our content, please like, share and comment and subscribe to our YouTube channel.